Okay. So this is case number P as in Paul 1095862, People versus Mark Alexander Peoples. The defendant is charged disorderly conduct. And I had ordered in this matter that the people were to provide discovery by yesterday, or the case would be dismissed. And if necessary, everyone was to return this morning. So good morning, counsel. Could I have your appearances, please?
Good morning, Your Honor. Tamika Horn on behalf of the people, P70303.
Deborah Choli, P34766. On behalf of the defendant.
May it please the court, John Royal, P27800, appearing as co-counsel on behalf of the defendant.
And you'd be waiving your client's presence, is that right?
Yes, Your Honor.
So Ms. Choli indicated to me that there was a difference of opinion about the discovery. You were provided with something, and your objection to what you received is?
Well,
Go ahead,
based
John.
upon our review, what we received is not really discovery about this particular case. This is an arrest that occurred on July 10th. And we have received a number of police reports on events that date in connection with other defendants. There is a list of arrestees in these reports that does list Mr. Peoples, but there's nothing in there that says what he is alleged to have done that resulted in his arrest. In addition, we've been told by the city attorney that the arresting officer in his case is an officer named Fox, whose name we cannot find in the written discovery we've been provided. Last week, we were provided what appears to be a police body cam video of another officer. And as far as we can determine, the only showing of our client on that video is after he's been in custody and is under arrest. So we don't have the video of any arresting officer or anyone who was in the proximity of the defendant at the time he was arrested. Under Michigan state law, where body cam videos are worn by an officer who makes an arrest, they are required to preserve the video until the litigation is concluded. And we haven't been informed what happened to the body cam video of the arresting officer or any other officers who were in his presence. If I could draw a comparison, there was another group of arrests a few weeks after this one on July 23rd, and the city provided us with 4 body cam videos relevant to that case. 2 of them of 2 arresting officers, 1 of them of the officer in charge of the police operation at that scene, and a 4th of the officer who actually wrote out the ticket. So in that case, we acknowledged that we'd received full discovery. In this case, what we've received does not tell us anything about what the city's case is or what evidence they plan to present at trial incriminating our client, and therefore it's not really the discovery that we are seeking. So we're asking the court to dismiss the case without prejudice, and if the city is able to find the relevant discovery, then the city can return to court and ask to have the case reopened. And that's been the consistent practice of judges throughout this court on these cases, where many defendants have been in the same situation. We've had over 200 defendants dismissed without prejudice so far. And the city has the option of trying to find the actual discovery and returning to court to get them reinstated. And that's what we think is the appropriate course of action in this case.
Ms. Ford?
Thank you, Your Honor, and thank you, counsel. It's the city's position that we've provided all exculpatory evidence that we have available and that is known to us. And so it's not, we don't feel it's our position to provide you what you agree upon or what you believe you should have. We've disclosed everything that we have available to us. We've tried to do it timely, while at times it was very difficult to obtain. We're required to provide what we have and not what you favor or what you like. We don't believe that these motions to dismiss are appropriate at this time, because we're not trying the case at this time, Your Honor. We're simply trying to provide what we have available and what is known to us. And then that's the city's position. Whether it stands at trial is another question, and motions to dismiss should be viewed in the light most favorable to the non-moving party, which is the city here.
Let me ask you this, Mr. Royal, supposing there is no video of your client's arrest or any video that shows unlawful action, so it would be your position that in that case, it would still require dismissal, is that right?
No, that's not our position. Our position is that the city law department representatives continually say they've given us everything they have, but they define that in an unduly, unlawfully limited fashion. Under case law that we've submitted in the brief we filed with the court, they are responsible for any discovery that's relevant that's in the possession of their office or the police department. And they continually try to run around that obligation by saying they've given us everything that the police department has given them. But under Detroit Police Department policy, all the officers in the vicinity of Mr. Peoples at the time he was arrested should have had operating body cams. The city has not informed us that they have checked the records of those officers who were in the vicinity of Mr. Peoples' arrest and determined what happened to the video of those police body cams. They're simply saying, we don't have it. And we think that it's an obligation on their part to at least provide some explanation. Has there been video that was destroyed by the police department, illegally destroyed? That would be important for the court to know in terms of our motion to dismiss. And
that would be speculative in our position, Mr. Royal. That is a speculative question.
It's not speculative. The Detroit Police Department keeps records of what happens with the police body cam videos. They're required by law to do so. State statute says that they're required to retain the body cam videos of officers who make arrests until the litigation is concluded. And if they violated that, we need to be informed of that so we can inform the court and make that part of our argument as to why this matter should be dismissed without prejudice.
And again, Your Honor, we did.
I'm
sorry, I beg your pardon.
So I am going to grant the defense motion to dismiss, and I've made a notation that the discovery provided does not show the defendant's arrest nor any unlawful conduct, and that it is without prejudice and the case could be reinstated if people find the appropriate discovery. Okay?
Thank you, Your Honor. Thank you. We'll submit an order, Your Honor.
Okay, you know what, Ms. Joey, today's my last day, so if you could do that today.
Like forever, your last day?
Yes, I'm retiring.
No,
we're gonna miss you.
Oh my goodness, I'm glad to have been here on your last day.
If I'd known, I would have brought a cake.
Yeah, we would have brought a cake had we known. Well.
Oh, virtual cake.